Hi, everyone. Harry here to talk about Jack Smith's filing in response to the order from Judge Eileen Cannon to engage with her idea of the law under the Presidential Records Act and to write jury instructions. Let me cut to the chase. It's the most important filing that Smith has done in this case since the indictment itself. That's because as Cannon has dithered and entertained crazy motions and theories by Donald Trump and not ruled at all and indulged delay, the clock has been ticking and everyone has been seeing which way the wind is blowing, excuse the mixed metaphor, but that is distinctly to the other side of November. And the question has gotten more and more exigent. When and how will Jack Smith try to really move Cannon to either, fly right, or that they will attempt to bounce her from the case before the 11th Circuit? She has made this a very vexing question, not just because she seems always to indulge Trump in theories that have make no sense at all, and kind of box the ears of DOJ when it's acting just fine, but also because she has seemed to fasten on a strategy, you could call it, of late, of not ruling and not giving the department something to grab onto and take up to the 11th Circuit and challenge her. And recall, she's had two strikes on her since way back when she went, upriver on this debacle of a mission with that totally playing as Trump wanted her to play on the search warrant, which she engaged a whole different litigation on and special master. The whole thing was crazy. The 11th Circuit slapped her down hard. And even though the 11th Circuit, not so easy to recuse, when you have a pattern of rulings, you start to get half the way home. And so she's been this whole time with that record there, and the 11th Circuit, hyper aware, including its conservative chief judge, William Pryor, of just what a, embarrassment, I think you have to say. It's not a Republican liberal conservative thing. She's just really, at best lacks game, and at worst is in the tank for Trump. Okay, so the order to which both parties were responding yesterday, Trump has made these different motions under the Presidential Records Act, and they are nuts. The Presidential Records Act, again, in brief, it's a way to clarify that almost all records belong to the people, not the outgoing president. The outgoing president can take diaries, a few, tchotchkes, but not at all classified documents. It clarifies, if anything, that there is no right to take classified documents, certainly no magic process for taking the most sensitive documents and, winking your nose and all of a sudden they're personal and yours. And moreover, completely irrelevant, because even if his totally ridiculous theory of the Presidential Records Act were solid, it wouldn't matter, because what he's charged with doing is possessing certain national defense information documents. And even if by some ridiculous legal theory they were personal national defense information documents, it wouldn't matter. The charge would still be totally valid, and he would be completely guilty. So he sounds this refrain again and again and again. And the obvious thing to do now, she holds off and holds off, but the obvious thing to do is now rule on it so she can rule for him. It'd be ridiculous, but the DOJ could take it right up to the 11th Circuit, or she could follow the law and really frustrate one of the two or three main theories. And he doesn't have much, but he's been dealt a bad hand under the law. That's just because he broke the law so flagrantly, and rule against him and, displease him. Instead, she tried to cut this weird middle path where she said, let's say his Presidential Records Act theory was sound. Now let's write jury instructions for this sound theory that I've just asked you to assume. And that's the strangest order I've ever seen. I said it, at the time, why are we talking about jury instructions first and foremost? An obvious answer, especially when you cobble it together with a couple other hints she has dropped in recent days, is, holy crap, she might want to rule for Trump, but at the jury instruction stage, after the trial has commenced, almost ended, after the jury is in the box, meaning after, in constitutional terms, jeopardy has attached, meaning you can't be retried. So if they went to trial and the jury were attached and then she dismissed the case for completely ridiculous grounds, jeopardy is attached. She can't be tried again, and there's no sense appealing her either because jeopardy is attached. He can't be tried again. So this is sort of the judicial equivalent of the perfect crime. Okay, enter Jack Smith, and here's why I say it's the most important filing he's made since the indictment. First, the judge has ordered him to engage in this academic exercise. He basically says, nah, I'm not going to do that. And I'm not going to do that, which is a sound, solid footing under the law, but not the kind of cheek one normally shows a district court judge. He said, that's and let me explain your premises, your academic premises you would like us to engage with, Judge. They're ridiculous. They make no sense. Here's why. So that's for starters, already a strong pushback. Then he said, oh, you want jury instructions? I'll give you jury instructions. And he lays out the jury instructions that would pertain to the case under the charge actually brought 793E of the unlawful retention of the national defense information material. And there's a little bit of the Presidential Records Act in there. He says at one point, because this would come up at trial if Trump is trying to proffer it, oh, jury, here's what Presidential Records Act are: diaries, personal things having nothing to do with official duties. In other words, blowing Trump's theory out of the water. That's here. You want your jury instructions? Here's your jury instructions. But then it gets stronger, because he then really, gloves are off. He says the whole thrust of the brief is, now, Judge Cannon, you need to rule on the Presidential Records Act. We can't be, messing around with academic exercises and the like. This is pending. You need to rule on it. Why do you need to rule on it? Because it's imperative. He used very strong language, and all of this is like, pushing back on a B- law student. We have to get these rulings well in advance of when jeopardy attaches so we can appeal. In other words, you're trying to keep yourself insulated from appellate scrutiny. You've got to rule now, and no more academic exercises, and the government has to be able to appeal well before jeopardy attaches. And he goes farther, does Jack Smith, than he ever has to say, because he puts in terms of the government having a right to a speedy trial, but it's just this far from saying the words, we need a trial by November because this man has to be held accountable, or that we have to have the ability to try to hold him accountable because we have election coming up, and this is all of huge paramount national importance. They've been very tiptoey about that exact position because it seems a little bit like it could be caricatured as saying, we want Trump to lose before November. It's not that. It's saying we want the people to have the benefit of this, whether he's a felon, by November. But he comes out of the box most strongly on that. And then the coup de grace. At the end, he talks about cases, a couple cases, not even from the 11th Circuit. They got the best they could. One from, I think, the Third Circuit, one from the Fifth Circuit. But it says, if you've asked a court to rule and they just haven't, and it could really matter for exactly this, you could stumble into trial and jeopardy could attach. That's a good situation for the M word, the 3-syllable M word, mandamus. So it's a elegant kind of final blow where he just puts out this proposition of law and then in parentheses quotes of a couple courts, and then it just says appropriate to use mandamus. You would just, if you weren't, following things closely, you would just gloss over it. But following things closely, mandamus just jumps off the page. And he's saying, I can summarize now what he's saying. Yo, Cannon, rule now or we are going to mandamus your ass to the 11th Circuit. And mandamus is a tricky thing. It's an extraordinary writ. I'm sure there was some discussion. Why not mandamus now? Why not mandamus? Because she hasn't given us anything enough to grasp onto yet. She's just said, do this academic exercise. So we have to have one more preparation setting of the table to say, your cockamamie exercise is inane and we're not doing it. Here's what the law really says. But you've got to rule. You've got to rule well before jeopardy attaches. And if you don't, mandamus. And now it's really set up. What they have now, even if, in other words, she continues not to rule and bob and weave and not issue a PRA ruling on the merits or other things, they've given notice. And it's pretty clear that, the undertone of a mandamus would be, she's got to rule and she won't rule 11th Circuit. Enough is enough. And that would put, given that they don't know what she's going to do and how much she's going to just sort of, gum things over and say, let's consider that a trial after jeopardy has attached. They've drawn the strongest possible line in the sand to say mandamus is coming if she doesn't rule and start dealing with these things in a way that preserves our government's appellate rights before we go to trial and jeopardy has attached. So a very forceful brief, a disobedient one, really. It'll be interesting to see what she thinks of it, because she ordered them to do something. They didn't do it at all, and then came back to say, and by the way, your whole order is full of it. Do your damn job or we are mandamusing you. And that's the message that strongly comes off the page and, really limits her operating room unless she's ready to get a mandamus. Now, you could take the mandamus and 11th Circuit could say extraordinary remedy. We won't grant it. And now they're back in front of her, in her clutches at her mercy. But 11th Circuit, if it sees what's going on, and they probably will, and anyway, she can't be certain what they would do, could well grant it. And then it's a whole new ballgame. Then you get a real judge who will move the case forward. It's, remember, a cut and dried case where he's guilty as sin and the penalties are strong. And if Cannon were gone, it would be a whole new day on that one. It would jump to the head of the class, perhaps, after the Bragg trial that starts in less than 2 weeks. So this is Jack Smith making his move and deciding, could have tried to wait for a holding. There's still this motion for reconsideration pending for 2 months. She's completely wrong. If she doesn't change her tune, they could take that up. But, they sat and thought this through and said, we got to do it now. Time is moving forward. We want to pave the way for a mandamus. And here's what that 24-page brief is. In the sort of paper world of the federal courts and the Mar-a-Lago case, it's a dramatic kind of throwing down of the gauntlet. And it puts Judge Cannon in something of a corner. And I don't think she'll, she could try to have umbrage over it. And you didn't do what I told you, but they've already considered that. They would not politely say, well, here's what you need to do, Your Honor. And if she doesn't, MANDAMUS. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.